Hello, everyone. Thank you for joining us at the Center for Technology and Innovation and Competition's most recent event to really highlight current events going on around the world in the law and otherwise. We are delighted to have you all here this evening online virtually. And it is a pleasure to put together an event with such blockbuster people that I will introduce briefly. A couple of words before I begin, just to make sure everyone understands. One, this is being recorded and will be made available to the public, so you should be aware that that is going to happen. If that is a problem, please feel free to exit and we would understand. Second, for those who are getting continuing legal education credit, please be aware that at different points during the course of the event, during 3 points, they will put up a word that appears in the poll that will give you the words you need to obtain proper credit and put on your form. And lastly, we do have the question and answer box open. We have a lot of ground to cover. And so I can't promise I can get to every question that we get in there, but we welcome your input in asking questions, particularly having such a distinguished panel that we think is really absolutely, I would think you'd be remiss if you didn't take advantage of the opportunity to ask questions. So without further ado, I would like to introduce our two speakers, Herbert Hovenkamp and Aviv Nevo. Herbert Hovenkamp and Aviv are both university professors here at Penn under the Penn Integrates Knowledge Program. It makes me feel greatly inadequate only being appointed in a mere 3 schools. They are actually both full professors in 2 departments. Professor Hovenkamp is often called the Dean of Antitrust Scholars in the country, holds appointments both in the law school and at the Wharton School, is known around the world for his expertise. Aviv Nevo is jointly appointed between Wharton and Economics and served as the chief economist, or what's often called the head of the Economic Analysis Group, during the Obama administration for the US Justice Department's Antitrust Division. I can't imagine 2 more knowledgeable people to have a conversation with. I could introduce them at greater length, but I think one thing beautiful about the internet is you can always get bios very easily. So I will dispense with that and get to the good stuff, which is we're all here today, which is the monumental and many events and developments we've seen in antitrust law happening these days, and it's very exciting to talk about. So without further ado, I'd like to start off by talking what I think is probably the highest profile of these in terms of the news. About a month ago, the House Judiciary Committee issued a report in its digital markets investigation, winding up a 16-month inquiry into what they call dominant platforms or digital platforms, and resulted in a massive 449-page report. We got the pleasure of seeing 4 CEOs, Google, Amazon, Facebook, and Apple, looking like big tobacco at a congressional hearing, all standing up and having to swear themselves in. And they made a whole series of recommendations, some asking for breaking up big digital companies, structurally separating them, changing merger presumptions, protecting against small competitors. And I'd love to bring both Professors Hovenkamp and Nevo in to get their reactions to the House report, and what do you think of the recommendations, and what do you think how influential you think it'll be? Why don't I start with you, Professor Hovenkamp, just because you're first alphabetically.
Okay, well, thank you, and thanks for inviting me. The report is long. It's a mixed bag. I think there's something in it pretty much everybody can dislike. Certainly people who don't want to do anything will dislike it. A lot of it could never be accomplished in the United States today without some statutory changes, but I'll just flip through what I think of as a few of the higher points. They want to go after the dominant platforms. So we're talking Facebook, Google, Apple, and Amazon. The dominant platforms, acquisitions of startups or smaller firms. And I share with a lot of people the view that that's an issue that needs to be confronted. If you look at the lists of acquisitions, by the way, Wikipedia maintains sortable lists of all of the acquisitions of the dominant platforms. there are hundreds of them, hundreds of smaller firms that they have acquired. The problem under existing law is that although the language of the Clayton Act is very broad, covers any acquisition whose effect may be substantially to lessen competition, in fact, we have guidelines, a century of case law that has served to narrow our law of mergers very considerably. For example, we don't have very much good law today on so-called conglomerate acquisitions, that is, acquisitions that are neither between competitors or between vertically related firms, or rather, many of these acquisitions really fall into the classification of what we call product extension mergers, where the acquired firm offers a product that's a little bit different from what the dominant firms already offer. Secondly, most of these acquired firms are way too small to hit the thresholds that we currently use in the guidelines for both horizontal and vertical mergers. Indeed, about half of them have a market share of 0 at the time of the acquisition because they've got a really good idea, but they really haven't made any significant sales yet. But the strategy here has to be a little different. We need to think of these things as exclusionary practices rather than as cartel facilitating acquisitions. Just remember, all 4 of the major platforms started out in somebody's garage. Facebook started out in somebody's dorm room, but they were all tiny, tiny firms with good ideas, and they know where their next competitor is going to come from. It's going to be some little startup, and so buying them up is a way to keep that from happening. Now, other things in the report I'm less enthusiastic about. For example, one is so-called line of business restrictions, or separation of platforms in commerce. So the idea that if firms need to kind of choose a more restricted range of products and services and leave the others to someone else. For example, there's proposals to require Amazon to stop selling third-party products. There are proposals to force Facebook to operate in a smaller set of markets than it currently does. I think most of those are very difficult to justify under any antitrust policy that's concerned predominantly with consumer welfare. The Amazon's own products on the Amazon platform serve as very good price pressure for the name brands, right? You go on the Amazon website to buy AAA batteries, you can get batteries made by Duracell. Now, Duracell is not a small company. Duracell is owned by Berkshire Hathaway. Or you can get Amazon Basics batteries a whole lot cheaper. And having those two things there in close juxtaposition puts a lot of downward price pressure on Duracell, and it's good for consumers. I don't think the consumer world's a better place if we require Amazon Basics batteries to be taken off of the Amazon website. The report wants to reverse a very troublesome piece of dicta in the American Express case a year ago, which is, we might talk about this later, the idea that two-sided platforms compete only with other two-sided platforms. That is, they don't compete with more traditional markets. It was categorically wrong. It was actually dicta because it wasn't necessary to the result in Amex, which involved competition among two-sided platforms. So I think that's a good thing. And then finally, and probably the biggest general thing the report wants to do, is it wants to get rid of or control what they refer to as self-preferencing choices within the platforms. Amazon is the clearest example. That is, it makes choices among products depending on whether it owns the product or whether somebody has paid for those choices. it's going to be hard to pull off under existing antitrust law because, we're very conservative in the US about the unilateral duties to deal. And a lot of those recommendations cross that line. Thank you.
Professor Nemo.
So I agree with a lot, or maybe even all of that. The report's very long, which, by nature of it, I mean, if you're going to write a 450 or so pages of anything, I mean, I'm sure any given person is either going to, like some of it and dislike some of it. Overall, I think, if I look at the general theme or where the heart is of the report, it's, in some sense in the right place. I mean, there's a lot of concerns. I think a lot of concerns among academics, among economists, among lawyers, but also maybe more importantly among common folks, right? I mean, at the end of the day, you kind of think, a lot of times as a lawyer, you say, oh, okay, who's my client and what does my client want to do, and how can I find a way to do that? To the extent that you think here that the quote unquote client for this report is the American public, I think there's a lot of support for the general themes of what they're trying to do and a lot of concerns about. That being said, I think there's a lot to find that one could be concerned with, and I'm not just talking about nitpicking about particular words or particular particular items. It's kind of more of particular themes. So if I look to the remedies section, which to me is actually in some sense the weakest part of the report. Say, okay, raise all these concerns, and we can talk about whether we believe with the facts, whether there's a proper case there for antitrust violations. Where I think the report really gets weak is they say, well, okay, so what do you do about it? And broadly speaking, I think the remedies were put into kind of three categories. One of these was to actually say, well, we need separate rules for the digital economy. And I think that's a very dangerous precedent to have. I mean, if we're going to start having rules for the digital economy, next thing we say, oh, we're going to have different rules for airlines, we're going to have different rules for something else. That's not, we might say, the existing rules, need to be broadened to deal with the modern economy. Okay, that's an argument we can have. But saying something, we need separate rules for the digital economy, I think that's going to be a bad precedent and bad principle that we definitely don't want to go that way. There's then, they move on to say, well, we got to change existing laws. And, that in principle, again, one could agree with, but there's very little details as to how that's going to be done. What are the specifics? And again, it's one of those things that might sound great to some people, but how exactly they're going to do that in a way that they're going to get support, get that through, and in a way that will be implemented, given the long history and the long, case law, that's going to be very difficult. And then finally, they talk about, the need for more review and more oversight. And to me, again, that's an area that we have to be concerned with, right? If I look and sort of say, you can have whatever complaint you have about the Antitrust Division or the FTC, but I'm not sure that, I'd want either one of those bodies, with whatever arguments you have about them, being, subject to oversight by Congress, which is probably, the least functional part of government right now. So that's something that to be worried about. The one thing that's striking to me that's not in the remedies, it was, earlier in some of the discussion, but was not in the remedies, was to say, there's Congress, if one thing Congress can do is give more money to the agency, saying they're resource constrained, and say, we're going to give more money, or at least have a call for more money. They did appear somewhere kind of in the body of, before they actually go to the recommendations and the remedies that they propose. But if you look at the remedies, they don't actually say that's one of the things we have to do. And that's the one thing they have the power to actually do, they didn't do. So part of me wonders how serious this all is, or if this is just 450 pages of, let's pretend like we're doing something instead of actually doing something.
Well,
Can I add one thing, Christopher?
Of course.
Oh, thank you. Yeah, I liked everything Avi said. It reminded me to say one other thing, and that is, he's right that the client here is really the public. But one thing you always want to resist is this idea that antitrust is kind of a an authorization to generally just go out and make the world a better place. There's too many places in the report that mixes up antitrust and non-antitrust goals. That's also true if you look at the minority statement responding to the report. Lots of concerns about suppressions of conservative voices, misinformation, and so on. Those concerns very quickly bleed outside of antitrust into other areas, and they are not within antitrust's own mandate, which is concerned about economic competition.
Yeah, I completely agree with that. And indeed, if you look at the, just before the remedies recommendations, there's a discussion of the harms. They mostly focus on things that are either outside of antitrust or on the very fringe of antitrust.
Yeah.
So I completely agree with her comment.
So I think this is fantastic. What I would like to, it's interesting to me. I sort of share the concern about the sloppy reasoning or the lack of justification to some extent. In many ways, they pull out anecdotes specific to Google, Apple, Facebook, and Amazon, then lump all of them together as dominant platforms and create, conclusions that span all four companies when, a search engine, a social networking company, a cloud computing, e-commerce company, and a device manufacturer are very different, and they don't necessarily generalize. And then they move to general changes in antitrust law that aren't specific to digital markets at all. I mean, they would like to change merger presumptions for everything. And it's what in law we call a non sequitur. It doesn't follow. It's, it may be the thing to do, but it hasn't really built the case on this. And what's striking to me is, a lot of it, as Professor Havenkamp mentioned, it's about vertical integration. Is sort of one of the learnings of the last 50 years in economics is vertical integration is often very good for consumers. And it can be bad, but in many ways, sort of a reflexive hostility towards it isn't always the right idea. And to throw out one other thought, one of the things they always talk about in the report is they talk about a Glass-Steagall for digital platforms, which is a structural separation statute from the financial services industry, dates from the New Deal, and was largely repealed about 2 decades ago. And what's interesting is I think a lot of people who invoke things like Glass-Steagall, or often they also invoke the AT&T merger, divestiture in the report. We're actually going to do some studies actually looking at the real history of that, because I think many people who invoke them don't actually understand what they really meant. So I want to go focus on one specific thing about you mentioned earlier. There's so much we can talk about. We talked about monopolization standards. They want to get rid of the recoupment requirement from predatory pricing, and to the extent they're specific, they're going there. But the nascent competitors is one thing I think that gets a lot of attention. And there was a recent merger that was approved in the US but barred in the UK, and so failed, between a company called Sabre, which is about reservation systems for airline mergers, and their attempt to purchase a firm called Farelogix. And what can we learn about this? It seems it's often positioned as one of these so-called killer acquisition or nascent competitor acquisition, because they believe that Farelogix was a potential future competitor to Sabre, and they were buying them up before they could get going. I'd love to have your reactions to these mergers, the merger, both the US decision not to block the merger and the UK decision to do so.
Shall I go ahead?
Please.
Yeah, that was a decision in the US District Court that was driven entirely by this little piece of dicta from the American Express case I mentioned a few minutes ago. In the American Express case, the majority asserted that a two-sided market, that was American Express, can compete only with other two-sided markets. Now, it defies any amount of empirical data and experience. Just ask, for example, the Philadelphia Taxi Cab Association, who was the plaintiffs in a major case against Uber about 3 years ago. The case would have been dismissed on the premise that taxi cabs and Uber don't compete with each other. Well, of course they compete with each other. And the issue in an antitrust case is whether one firm has the ability to steal sales away from another firm sufficient to hold that other firm's prices to its cost. That's an empirical question. And the answer varies greatly from one firm one firm to another. Nevertheless, given this dicta, the judge in the Sabre case basically said, well, this is not a merger of competitors because you've got a merger of one two-sided market and one firm that's not a two-sided market. And so he dismissed the complaint. The merger was later abandoned when the EU came out the other way. But dicta from the Supreme Court have a lot of weight, even if they are dicta. And this one cuts both ways. Let me just give you an example. Carvana. Maybe some of you know Carvana. Carvana is a two-sided platform that sells used cars. You can post your used car to Carvana, and other people will buy it later on. Carvana's market share in the used car market is less than 1%. The other website, two-sided market that sells used cars in the United States is eBay, which has a division. Its market share is also 1 or 2%. However, if they should merge in the United States, a court following that statement in the Amex case would have to conclude that that's a merger to monopoly, because we don't pay any attention to the fact that the other 97% of used cars in the country are sold by traditional car dealers. So it's a piece of dicta that I think is going to prove very damaging, and I hope the Supreme Court straightens it out within the next couple of years.
So let me just start with a disclosure. I mean, I know many people know this, but just to make sure everyone does. So I was involved in that case. I was actually the economic expert for the DOJ in that case. So take whatever I want to say, whatever I'm about to say with whatever, whatever grain of salt you want to put on it, just so you know. So I agree, I think, in terms of, there's a lot of discussion of nascent competition, potential competition, acquisitions by platforms of firms that do, stuff that's a kind of a small component of what they do or adjacent to what they do. And in many ways that describes the Sabre Faralogic case. And I think what happened there is, if you actually read the decision, you read the first few pages, I forget what it was, 30 or so pages, and you think, and if you didn't read the first page, just, from page 2 onwards, you read that and you say, the judge is going to find for the DOJ. I mean, he talks about how they're competitors, how they compete, how they see each other as competitors. I mean, it really sort of lines up with a lot of the arguments that were made in court by the DOJ. But then, at some point there's a turn, and basically, if you jump kind of to the end of the report, it ends with exactly where Herb was talking about, that the judge says, well, regardless of what I think, the Supreme Court basically tells me, and Amex tells me, two-sided platforms can't compete with one-sided firms, and therefore this is all irrelevant. And then I would say the middle of the report is about trying to, in some sense, put these two things together, which is the fact that they do compete. They viewed each other as competitors. The irony of it all, by the way, is that at some point, Faralogics tried to become a GDS-like entity, about 10 years or so, or even a little bit more. And basically, Sabre took steps to prevent that from happening. So Faralogics changed its strategy and decided to very specifically focus on a kind of a particular, basically one side of providing a technology that better allowed the two sides to connect. I mean, I can go a lot more in detail on what they did. And essentially, most of that decision is about trying to reconcile the facts, which talked about competition, and the Supreme Court that didn't, and in the process trying to mash this together with some of the economic evidence. So I think, it lays a lot of the grounds and the difficulties, and actually, in many ways, this is an easier case than some of the other cases, because actually, in terms of shares, Faralogics was small, but actually some of the deal projections themselves had, a fair number of transactions going through Faralogics, just a question of how they should be counted. So there is a sense in which, relative to other acquisitions of potential competition or nascent competition, there was a way that one could get to a presumption here. Okay, the judge obviously did not agree with that way, but there was a way to get to that. And I think it actually highlights the difficulties that one would face trying to bring a nascent competition case under a Section 7 case. And again, you could disagree with a lot of your own specifics that were done there, but it shows the difficulty. Two other things about that case that are interesting. One, as Herb mentioned, the case, so the merger was actually abandoned because it was challenged by the CMA. Basically, the CMA forbid that. Interestingly enough, Sabre is now suing the CMA over that decision, even though they've already abandoned that that ruling. I just saw something come out that was, I think the hearing for it just happened a few days ago. Okay, so that's one, and it does tell you, if you actually read the CMA report, it shares a lot with the DOJ complaint. It's not exactly the same, but shares a lot of the same characteristics and shows you the difference in the environment, right? The somewhat more regulatory environment that exists in the UK versus what we have in the US. So that's one point. The other point that's worth mentioning is, so there's another case ongoing right now that the DOJ filed against Visa. So again, another two-sided platform. And it's acquiring Play, which is one of these kind of fintech firms. I actually have nothing to do with that particular transaction. And what's interesting, if you read in that complaint, is that that's actually being brought as a Section 2 case. And I don't know if it is or it's not, but one could imagine that that's the DOJ learning about the difficulty of bringing a case of a two-sided platform, purchasing a nascent competitor, one-sided platform, realizing the difficulties of bringing that under a Section 7, and therefore bringing it under a Section 2. I don't know if that's the case or not, if they were going to do it anyway, but it seems like there's a little bit of learning here going on by the DOJ.
So it's funny, Herb, you mentioned, first off, have you mentioned Amex twice? As you know, you signed an amicus brief supporting the dissent's position. I was on the other, I signed on one on the other side. I think that, you know, you both identified a dicta that is regrettable in some ways. And in fact, Supreme Court dicta are extremely influential to the lower court. It's like holdings to lower courts, and we know that. My hope is that there are ways to read Amex that are more charitable, which is it's not so much that they're not in the same market, but you have to take into account the net effect on both sides. And that the measure, and you mentioned the Uber case, in both Amex and Uber, as they looked at whether total transactions went up. And Uber, that was sort of, you know, in a sense, it could have been gone off on market definition, but they did mention in both cases the fact that really that in fact consumers seem to benefit from it. And that was, if that ends up being the learning from all this, I think that would be really helpful. But to go back to this idea of the nascent competitors, one of the most controversial aspects about barring acquisitions of nascent competitors is many new companies are created to be bought. I mean, that's one of their, at least one of their major exit options. And the question is, what are we going to do to innovation if basically we cut off part of the market for the innovative companies? They might go public, and we have examples, you know, the Netflixes and the Ubers of the world have managed to do that in the modern era. But others actually, the preferred outcome because of the scope of the product, whatever, is to be bought. And if we stop those, how do we separate the good nascent acquisitions that we should allow to go forward and the bad ones that antitrust should block? Do we have tools to do that?
That's an extremely good, important, and very difficult question. But fundamentally, acquisitions have what you might call an exclusion value and an integration value. The integration value is virtually always a good thing, right? Firms get bigger and they attain economies of scale or scope. They extend their markets and so on. But integration values all require that the acquired assets actually be used and incorporated. The exclusion value from these acquisitions comes because the acquiring firm is basically pulling the acquired firm out of the market and making it unavailable. Now, there are some approaches that could segregate those two. One, for example, would be to limit such acquisitions to non-exclusive licenses. The vast majority of these acquired startup firms have assets that are composed basically of two different things. One is intellectual property rights and the other one is human capital. I mean, they have buildings and other things like that, but those are trivial in the calculus of these mergers. The main thing that the platforms are after, like Facebook when it acquires WhatsApp, is it wants WhatsApp's intellectual property rights. Well, intellectual property rights have the unique property that they can be divided. They can be divided indefinitely. And one thing we could do is say, Facebook, okay, if you want to take advantage of WhatsApp's technology, you can obtain a non-exclusive license that will give you everything you need to integrate WhatsApp's technology into your own platform. What it will not give you, however, is the right to extinguish WhatsApp as an independent technology. I don't think that will work for every merger, but it could work for some. Beyond that, I think we need to start looking back, and I'm a little cautious about saying this. We went through a lengthy period of time, and particularly in the 60s and 70s, when we went after conglomerate mergers, product extension and market extension mergers. We did it through some fanciful theorizing, but I think the networks are providing a new platform for evaluating those kinds of acquisitions again, because there are anti-competitive effects. And by the way, I agree with Avi's point a few minutes ago that for some of these, Section 2 might be a better vehicle simply because what we're really not concerned about price increasing conduct, which is the concern with mergers, that the firms are more likely to collude in the firms in the market and so on. Well, these are really exclusionary practice cases. That is, the long-term strategy of the dominant platforms is to keep new platforms from emerging, and a series of repeated acquisitions will do that. The problem they confront, however, as a Section 2 strategy is that there are so very few markets in which the dominant firms are actually monopolists. That's something that is difficult, I think, for a lot of lay people in particular to get their hands around, because these firms are so big. Amazon has arguably a dominant position in ebooks, but if you look at the great majority of products that Amazon sells, it does not have a dominant position. Facebook, if you take this massive amalgamation of services that Facebook offers, it looks very big. However, in every single individual market in which it operates, messaging, sharing of photos, sharing of videos, etc., Facebook has a lot of competitors and pretty much a non-dominant market share. And so you need to be able to come up with some kind of market definition that treats them as dominant firms before you can apply Section 2 analysis as it currently exists in the United States. Now, the EU has a more advantageous statutory structure because it articulates the concern as abuse of a dominant position. You still need to find a dominant position, which it will find on a lower market share than we do to find a monopolist in the EU. In the US, but abuse of a dominant position can also refer to non-monopolistic harms in secondary markets. And that, I think, explains why the EU has been able to leverage some offenses with respect to the platforms that we have been unable to do in the US.
So what's fascinating, a couple things, just so you know, I mean, if you look at the EU's case against Amazon, on information sharing, they are using as what we call a Section 2 theory instead of a Section 1. They're going on it as an abuse of dominance case, which is novel for them. They've always thought of information sharing as a Section 1 case where it's about sharing information. And it'll be interesting to see they're actually experimenting in the exact same direction I think both of you suggested, which is to think about this as an exclusionary case, a single firm unilateral exclusionary case.
So I think, Christopher, going back to kind of your original, your question, um, I think one has to be, and I don't know, maybe we still have to kind of think of this more and understand, but I think painting a brush of a, you know, all acquisitions of nascent or potential competitions are bad or all are good, neither extreme is correct, right? So if you want to go and sort of say, look, we're now going to prohibit all acquisitions, that's probably the wrong policy, right? Now, where exactly do we draw the line exactly along the, the issues that Herb talked about? I mean, it's going to be difficult, but one of the issues also we have to take into account is what other nascent potential competitors are there that are doing that same thing? Because it's very easy when you go look back at some acquisitions, and I'm not going to give specific examples, but many acquisitions and look back and say, oh, it was obvious that this was the competitor, this was the obvious competitor they were buying early, but it wasn't obvious at the time, right? If you put yourself at the time and look at who else was doing something similar, there were many others. Now, it could be that whoever is doing the acquisition is just good at picking winners, right? I mean, it's the equivalent, I don't know, I mean, not that I'm acquiring that any university has, market power in doing so, but think of, acquiring young faculty, right? At any given point, there's a lot of young faculty in the market. Who knows who's going to be the next superstar? And some people are maybe better at doing that than others, right? And it could be that that's a talent that someone has, right? Take whatever CEO you want of any of these firms, that they're able to do that. That's a talent. They might be, they should be able to get the rewards of that, because it could be that left on their own, this nascent competitor dies off, because most nascent competitors actually don't succeed, right? So that's where I think it's very important to look, and and again, going back a little bit to the Farelogix case, the Sabre Farelogix case, there it was very clear Farelogix has established itself. It had a track record of actually being the leader, and that they were unique. And Sabre itself kind of admitted, so it's not like you're actually buying someone and saying, taking the chance we're going to develop them, right? Because there's 10 like them. They were unique. And I think that's one thing that distinguishes, or can distinguish certain cases.
So I think this is a great topic. We could go on. I don't know. I'm watching the Q&A. First, you're right, Aviv. If people could predict which the winners would, so often we'd all be rich and be sitting on the beach someplace, and we all know that that's really hard to do. But Steve Dedelis in one of the Q&A says, and makes a very similar point, which is sometimes you need these small companies need access to the resources of large companies, and it actually reminds me of David Teese's famous article in Research Policy, Profiting from Innovation, where they're saying often the innovation has to be combined with other complementary inputs in order to survive, and in order to be fully realized. And if that's the case, actually the solution he recommends is, especially if it's intellectual property based, you'll get beat up to marginal cost pricing after the fact. So some sort of ex-ante commitment through vertical integration or some other long-term contracting is often a solution for that particular problem. And I find it's a much, I think your point about Professor Nemo is not making it so simple, black and white, but to get analytical traction to try to separate some of these cases. And also another colleague of ours, Marshall Van Alstein, raises a question about Instagram didn't have any IP. And so that's a tough question about how to do that. The flip side is, if it is patented IP, you actually have a legal right to do exclusive licensing, necessarily. And it's an interesting question there about how we balance this all out. I wish we could talk about this more, but I'm going to push us on to the next topic because there's a lot more to talk about. The other thing that's huge in the news these days is the big US filed a complaint against Google. I will tell you about mostly talking about their what they call exclusivity agreements with Apple, Android device manufacturers, different telephone providers, and browsers. I've seen a lot of reactions to it. A lot of people were, I think, surprised by the lack of detail, and it didn't seem to go much past what the previous 2013 investigation to do. I would love to hear your reactions to the Google complaint, understanding that it's still very in the early stages and it's very hard to make out what's going to happen. Go for it, Herb.
Okay, thank you. Yeah, okay, a couple of interesting things about the Google complaint. First of all, it was filed in a Republican administration. I don't expect the Biden administration to drop it. If anything, they will expand it. Secondly, it contained no Section 1 allegations. Aviv mentioned this issue a little bit earlier in a different context, but you start looking at the facts in the Google case, and you see all kinds of challenges to agreements. Probably the most prominent is the one Christopher just mentioned, that Google pays Apple a bundle of money every year in the billions of dollars for Apple to make Google search the default search engine on iPhones. That to me seems like a fairly easy and obvious Section 1 claim, but it's not being brought as a Section 1 claim in the current version of the complaint. Now, just keep in mind, in federal district court, you get one amendment as of right, and so the Justice Department can amend this complaint to include Section 1 violations anytime it wants. But they're currently relying entirely on Section 2. The other thing is that the complaint is much narrower than the full range of things that have been discussed with respect to Google. It focuses very heavily on Google search and some of the advertising contracts. Third, however, even under that rubric, parts of it are going to push the law pretty hard. Now, I'll just give you one example here. I think the easiest thing for the government to win on in that complaint is the big payment of money to Apple to make Google search the default search engine, okay? Google search is also the default search engine on Android devices. But the big difference is that Google owns Android. And as a result, that is unilateral conduct, as US antitrust law defines it. And, you know, in order to challenge, so basically, just get a picture here of what we're challenging. We're saying that in Google's own operating system package, it makes Google the default search engine. That's very largely unilateral conduct. Now, it does have licensing agreements with Android device manufacturers. Those could raise Section 1 issues, but Section 1 issues haven't been raised yet. Google search is one clear example of a dominant position among the tech platforms. Assuming the market is defined as general search or something of that nature, Google has a market share north of 85 or 90%. So it's clearly a dominant firm in the search market. And that's not because it doesn't have any big rivals. Bing is a Microsoft product. Yahoo is a very large product. DuckDuckGo is a pretty large product. But nevertheless, Google still has a very, very large, very large market share. And then finally, one other point, and I'll shut up about this, and that is the complaint is totally non-specific about the remedy. It simply says whatever equitable relief the court deems proper after the record has been established. I think that got a few people irritated because they would have liked to see some kind of structural relief, maybe a divestiture of Google search or a separation of Android from the rest of Alphabet as parent company. But none of that is in there. I can tell you that there are promising remedies that the government could ask for. However, they're rather novel ones. And one of them is interoperability of information. That is to say, the reason Google search has such a big market share is because it kind of feeds on itself. It collects information from users processes that information, and because it has a bigger database than anyone else, it produces better search results than anyone else. Well, if that information, remember, that's not Google's information, it's their users' information. If that information were subject to an order that required it to be shared by anybody who's willing to share their own, so that the various search engines all had access to the same information database, and they would then compete on such things as the formulation of their search algorithms, that might be able to level the playing field without requiring anything quite as draconian as divestiture.
So I largely agree actually on the complaint. I mean, if you would have told me, 24 hours before it came out and said the complaint's coming out in 24 hours, do you care to guess what it might have in it? And here it's just a matter of, just aggregating stuff that's already either happened in the EU, or, if you look at the CMA report, or, various papers that were written after that as roadmaps of how one could bring a case, seemed like they had a lot of very different issues in them. And this seems to be a fairly narrow. My guess is it might also, if I had to guess, it may be because there's a feeling this might be the safer route to go. But as Herb said, I think there's still a lot of huge obstacles, even in this so-called safe route. The other thing that Herb touched on that I completely agree on is the lack of remedies, and not just here. I mean, this goes back to, some of what we talked about in the House report. If we talk about, I know some other cases we're going to be talking about, there seems to be this idea of like, let's just focus on, coming up with a theory of harm, maybe not even get the, how do we prove it? How do we make the case? Let's just come up with that. And, remedies. That's like 3 orders of magnitude beyond what we've actually looked at. I mean, I get that, that's the impression again, and we can talk about some of the other cases. And that's a huge mistake. I mean, if you think of both the DOJ and the FTC, they are the expert agencies, right? That's where the expertise lies. And if they can't come up with remedies, asking a general judge to come up with it, I mean, that's a huge leap of faith. I mean, judges are obviously very smart, right? They got to where they are for a good reason. But, you're taking someone who's not an antitrust expert and throwing on their lap almost an impossible problem. I think in some sense, that's kind of walking away from what your responsibility is. I mean, you still have to convince a judge that your remedy is a good one, but you first have to come up with one, right? And again, I'm not just talking about Google. It's something that, appeared in other cases as well. Let me just react to one thing that Herb said about the information sharing and data portability. I mean, there's a sense in which I completely agree that would solve a lot of the issues, but I think that puts us up against various privacy questions, right? And now the question is, as a user, okay, I now at some point agreed or was forced or whatever, whatever the case might have been, to give my data to Google. And next thing I know, now because of some agreements and settlement, now it's getting passed on. And who knows to where it gets passed on and what assurances I have of my privacy, and whether this actually solves problems or makes them worse. Let me just stop there.
So what's
let me add one word about remedies, because I completely agree with Aviv. The U.S. track record, and this is mainly the Justice Department, on Section 2 remedies is truly awful. I mean, it's not just weak, it's truly awful. I mean, the big early case was Standard Oil in 1911, which broke Standard Oil up into 34 companies, and immediately the price of gasoline went way up, so much that 4 years later, the newly created FTC found it necessary to write a 3-volume report trying to explain how it was that we broke up this monopoly, and then suddenly gasoline got a lot more expensive. In the Grinnell case in the 60s, the government broke up ADT Homes, which was the major provider of hardwired home security services, and they did it by breaking up ADT into all of the various cities in which it did business, apparently not realizing that all that did was create a bunch of little monopolies rather than one big monopoly. And of course, the most recent one is Microsoft, where the government did request structural relief, and then ultimately the DC Circuit refused to grant it. But it's hard to come up with Section 2 remedies, structural remedies that have actually resulted in higher output and lower prices. Way too many of them do just the opposite. Structural remedies are, of course, a little more obvious in merger cases where you've got a recent acquisition or even more a prospective acquisition. But for monopolies, we have just had a very, very bad track record. And I don't blame the government for being a little bit gun shy if that's what's if that's what's going on. But I have a hunch they don't really know what kind of structural relief would be appropriate in this case. If the goal, I mean, I always start with this point in my classes, the goal of the remedy has to be consistent with your overall goal for antitrust. If the goal is output increasing, sustainable output increasing behavior, right? That's what the consumer welfare principle says. We want the largest amount of sustainable output, which is consistent with low prices. If that's the goal, it's not easy to come up with a structural breakup that's reasonably calculated to achieve that goal.
Well, that's, you make a great point, Herb. The relationship between the theory and the remedy has to be there. I mean, one of the criticisms that a friend of mine, Tim Brennan, who is an old antitrust division litigator, has said, the evidence in the theory had no relationship to divesting Microsoft Office. I mean, they were all about defensive leveraging and the browser, and the structural relief sought just took a left turn. Here, if the theory is about exclusivity contracts, the obvious remedy is to bar the exclusivity contracts. You know, just simply, it follows naturally from the theory, but that doesn't create the kind of blockbuster structural relief that many people are looking for.
I think a well-designed injunction would probably do a whole lot better than a divestiture. I mean, looking at the current Google complaint, the two things come to mind. One is enjoin the payment to Apple to make Google search the default search engine and let Apple decide that for itself. Importantly, Apple may decide to stick with Google just because Google is the most popular search engine. With respect to Android, the EU has come up with a pretty good solution, which is they've added a startup screen to new Android devices. You buy an Android phone, for example, in Germany, there's an extra startup screen and it lists, there's a list of search engines on it. One of them is Google, one is DuckDuckGo, one is Bing, I think there are 4. And then the 5th one is an empty line where you can type in the URL of your preferred search engine. And so you let the consumer decide. Those are not structural remedies, but they take away this default. And then, of course, we're still left with the question of would Google continue to be a dominant firm if it no longer had the benefit of the default? That's a very hard question. Maybe we want to get into it later. I'm happy to talk about it, but the question of the role of defaults in antitrust issues, in antitrust policy today is extremely complicated.
Well, there's a point I've heard you make before, Herb, which is defaults, Windows 10, 90% of the users changed it to the default search engine to Google, even though it was shipped with Bing. And so there are, and the browser share they've got for what they bought is 60%, but Google share is 90% of search. Yeah. And so there's clearly more going on here than's going on. But what always struck me is a lot of the ecosystem, whether it's browsers or phones, the auction of the default search engine is a critical revenue stream for them. Like Mozilla has said, they can't survive without it. And what's fascinating to me is, when you think about what we're arguing is we're trying to protect other search engines. We're trying to protect Microsoft, which is deeply ironic given that this case is patterned after them. But frankly, they're on a par with Google in terms of global market cap. I mean, they're not exactly the people we think needs protecting from a bargaining situation. Then, you know, it's when you get into who are actually protecting, it seems like a very funny argument to make.
Yeah. Right now, empirically, it seems that defaults are a whole lot stickier on handheld devices than they are on desktops and laptops. People are pretty free about switching defaults on their big computers. And the one you point out is Windows. Windows 10 is bundled with what's the successor to Internet Explorer?
Edge, I think.
Edge, yeah, thank you. Is bundled with Edge, and Edge is bundled with Bing as their search engine. 90% today, 90% of the people who buy a Windows 10 computer start it up, load up the Microsoft browser and search engine just long enough to download Google search, and then they switch. So, you know, being the default search engine on a Microsoft desktop is really not worth all that much. You get just the opposite experience with handhelds, where Google search is the default today in the US on both Android machines and iPhones, and very, very few people switch away from it. And so then the question is it because it's harder to switch defaults on handhelds, or is it simply because the default is Google and everybody prefers Google on its own merits?
So I want to push us on to the Facebook case briefly. So one of the things we talked about is structural relief. And we don't have the case. The FTC promised to bring it by the end of November. Please say it's December 2nd. That didn't happen. But one of the things on track for on tap or potentially is to force Facebook to divest its acquisition of Instagram from 2012 and WhatsApp from 2014. And that's kind of gross structural relief, you know, for these sorts of things that we've talked about before. I'll start with you, Aviv. What do you think? Is this, how likely do you think that's going to happen? Are you a fan of this type of breaking up, you know, now what's an 8-year-old transaction? What are the thoughts that go, you've been on the enforcement side, what are the thoughts that go into weighing whether to seek that kind of relief?
So let me not, answer as to what I think the FTC might be doing with Facebook, partly because, as I said earlier, and you asked me the same thing about Google, I would have been completely wrong. So given my, you'd have to take me my really poor track record, let me not try to repeat it where you can actually test it. But let me sort of speak, just kind of on the ground that you've said, and actually even taking it beyond, specifics of Facebook and Instagram. There's been some calls, I believe, Scott Hempfield and Tim Wu have a paper that they say, well, the way to deal with nascent competitors is to actually say, why don't we, not worry about it at the kind of ex ante stage, right before it happens. Let's let it happen and let's see what happens. And if we don't like it, then we'll undo it, right? I mean, I'm paraphrasing here. That's probably not exactly what they said, but that's kind of the spirit of it. And you could sort of say, looking at, Instagram, Facebook, you might say, look, we don't like it because these guys ended up both being, I don't know exactly what a social network is, but okay, they're both kind of the same. The problem with that is you don't know, had that been, so there's I think as a general matter, there's a policy issue of any merger. If you're going to go 8 years later, right, and undo it, where's the limit, right? I mean, is 8 years sort of too much, or a year or two? I mean, how long are you going to let it before you got to say, look, we got to, in some sense, leave it alone? Because if the idea is that there's always a threat that you're always going to go back and try to undo a merger, that just, completely changes the incentives to invest and realize efficiencies from a merger, right? If you basically say, look, I'm going to invest, and if I'm going to invest and do well, and you're going to undo it, then why should I invest, right? So I think, there is a general policy issue as to whether you want to look back. And obviously you can't sort of say, look, you can't, once it happens, you can't touch it. But there is a limit of, is 8 years too many? I don't know, but there is kind of a point where you have to take that decision. So that's the first. The second is you have to be very, very careful in looking at any merger ex post, and not whether it's Instagram or something else, any merger, looking ex post and asking yourself, what was a bad outcome, right? So is a bad outcome to think that the acquired firm really succeeded and did well, Is that a bad outcome? Or is it that it did very poorly, right? Because there's all this kind of issues of killer acquisitions, right? So now we're sort of saying, well, if they do really poorly, that's bad. That was a killer acquisition. If they're going to do really bad, that was one that the agencies missed. Okay, so there is like that middle ground that no one can define, right? You say in that middle ground, we're going to let you go. So it just seems to me, I mean, this is just asking for trouble, kind of defining that. It's issues of causality, of sort of saying, you know, maybe you did well exactly because there were efficiencies. Maybe you ended up being very much like the acquired firm because that's what we do, right? If you're, you know, you're McDonald's and you buy another chain of small, you know, fast food, you know, what I do is hamburgers. So you make them make hamburgers as well. And next thing you know, you're saying, hey, look, the two are the same. So I think there's a lot of, you know, hard questions that are going to be have to answer it if you want to go ex post and kind of undo a transaction. And how do you kind of answer all these questions that I just posed?
I agree. I can't even conceive how you would go about forcing Facebook to divest WhatsApp. I mean, are you going to force the customers to go back and abandon Facebook? No, you can't do that. You can create the entity, but you can't guarantee the survival of the entity in the marketplace. And there's just way too much water under the bridge for that by this time. If these acquisitions are going to be challenged, they should, if at all possible, be challenged before they occur, and maybe a little bit of room for a challenge within a short period after they occur, but before there's significant integration of facilities. Once they're integrated, and particularly when you're talking about firms whose principal assets are intellectual property rights, everything is going to flow into everything else, and it's not like it's not like Chevrolet divesting Oldsmobile or something like that, where you've got a discrete plant, a discrete set of products, and you can just force return to the status quo ante. It just doesn't work in cases like tech platforms.
So the first conference I organized when I came to Penn was the 25th anniversary of the break of AT&T. And I actually invited the engineer who broke up AT&T, who determined where the assets went. It was incredible because that was a company that was never designed to be done that way. And you start to see a flavor of what you're talking about, Herb.
Yeah.
So there's another thing that in the Facebook case is the FTC is thinking about proceeding with it administratively instead of in court, which is, it has a capacity for doing that and limits its remedies. A lot of states are very upset because they're not going to be able to participate in that if they go proceed administratively. And we see in the Google case, it was brought in conjunction with 12 other states, but Texas is talking about bringing its own case separate from that action. 7 states are another coalition talking about bringing yet another action. You know, again, Aviv, I'd love to talk to you. You sat on the federal enforcement side and must have had interaction with the states in some sense of, are these separate suits helpful? I mean, obviously they have the right, they represent people, but we saw in the Microsoft case, the states proceeded with their own case and basically got shut down. So I'd love to have you, not even talk about this case in specific, but just talk about the interaction between federal and state enforcement from your experience in the department, in the Justice Department.
So as an overall matter, I mean, I think it's good to get states involved for a variety of reasons. I mean, partly it's kind of shows, okay, there's uniformity of kind of belief of concerns. I think it also helps in the long run to actually get states involved in thinking about antitrust. Because, you know, we like to think about, you know, Amazon and Google and Apple and Facebook and whatnot. But, you know, there's a lot of very kind of small local places, right? I mean, you know, you have 2 coffee shops in a local area kind of merge. I mean, that's not something that's going to get under the radar. And of course, I mean, that's extreme what I'm saying, but, you know, that's not going to go to the radar of necessarily the federal agencies, but could still be a concern for people living in that town. And I think having kind of antitrust thought of even kind of at a more local level would be good. And strengthening the antitrust capabilities of states is good. And that happens through kind of working jointly. That said, there's a little bit of tensions because, you see it actually, especially in merger cases. I mean, let me talk about something that was actually public. It was during my time at the DOJ, but it's public and I can talk about it. If you look at the American US Air merger, right, that there, the DOJ brought it with, I forget how many states, but, a number of states, the merging parties basically went off and were able to pick them off, one by one. At the end, and partly they did that with certain behavioral remedies about promises to not shut down certain hubs or, keep employment at its current level for, N years or so. Stuff like that, the DOJ would never have accepted as part of a settlement, but states were happy with that and signed off. So it created a weird dynamic that you start with a coalition and suddenly your coalition is dwindling and, just the appearance of that doesn't actually look very, very good. So that is, I think, in terms of kind of going together. Now, there's a separate issue, and you saw that in the AT&T Sprint merger of actually states going on their own. Okay, not even necessarily going with a federal agency, whether it's the FTC or the DOJ. That I think has its own issue. On one hand, you could say it's good, right? I mean, if we believe in competition, then competition and enforcement is probably good as well, right? If we have one more set of eyes looking at issues. That said, I think states actually have a hard time bidding some of these bigger cases. And you can see a little bit of that as to what happened in Sprint T-Mobile.
Well, so we are running long. So I'm actually just going to, instead of asking separate questions I had about different topics with developments in Europe, I'm going to throw them all in one big schmear. So we have Spotify against Apple case brewing in Europe, which is paralleling Epic's challenge against Apple in the US. We have a statement of objections in Amazon against Amazon. And we have a major development, which is an experimentation of what's called the new competition tool as part of the Digital Markets Act. Things are clearly moving in much more aggressive directions in Europe than they are here. Given that we're running a little long, I'll just sort of put it out there and allow even Herb, you to take it, any of those threads that you'd like to pick up on that particularly interest you and take it any direction you'd like.
Okay, well, with respect to Apple, there's some commonalities between the EU investigation and the private suits like Epic, but their main complaint is that the App Store is a bottleneck. If you buy a desktop and you want to buy software or something, you can go to a number of platforms and there's a lot of choice. But for the most part, if you own an iPhone, you buy your software through the App Store. If you own an Android phone, you buy it through Google Play. The commissions are high. I mean, any external observer would look at those 30% commissions and say, well, the platforms don't hardly do anything. The App Store, the app manufacturers create the apps and post them, and the main thing Apple does is cash the check. And so, the complaint is that we've created these bottlenecks that everybody who owns an iPhone has to buy their app through the App Store. Spotify, in particular, has been injured by this. Spotify charges money to its customers for its subscriptions. Apple adds its own commission on top of that, and as a result, that places Spotify at a significant disadvantage to Apple Music, which is owned by Apple, but is another competing music store. Once again, with respect to US antitrust law, it runs against unilateral refusal to deal law, right? This is Apple's unilateral decision about how it wants to sell a product on its own platform. And we're going to have to soften up Trinco a little bit. So the principal US refusal to deal case in this context, Aspen doesn't apply because there wasn't a history of voluntary dealing here. And so that's a major hurdle, particularly with this Supreme Court, who I don't think is going to be very enthusiastic about expanding the law. unilateral refusal to deal. Now, on the new competition tool in the EU, it's hard to say very much about it because we don't know very much about it yet. Actually, there's going to be a press release or a release of some sort, I believe a week from today, in which we're going to hear a little bit more. But the EU is in the process of creating some set of rules or devices that will enable attacks on platform dominance prior to the occurrence. That is, to go after incipient dominance, you might say. A conservative in the US looking at this would say, well, they're taking a set of positions on platforms that's already aggressive, and they're making it even more aggressive. Now, let me just add a couple of things. First of all, European Union does not have an attempt defense like we do. There is no attempt to abuse one's dominance. So in the US, we have both monopoly and attempt to monopolize. So you might say, well, this is kind of an equivalent of attempt to abuse a dominant position. I'm not sure how much water that's going to carry. Or you might analogize it to merger law, which, where we say merger law has a prophylactic purpose, which is to go after certain mergers early, even though the worst effects haven't yet borne fruit. But I'm a little bit suspicious at this point. I need to be satisfied about what it is, but like I say, we won't know yet for another week, if then.
So I agree with all of that, and obviously I have very little to add in terms of the, comparative of the law. But so looking at the Europeans, it does seem, that there's a lot of cases that are potentially based on at least, solid economic theories, whether they're relevant or not, if they match the facts, I don't know. You have to kind of dive in. Herb talked about the Apple, the App Store, that, you could see them coming under, being brought forward in the US. It does seem right now, though, that there is a certain environment in the US, and I'm not quite sure what it is, if it's temporary, if it's going to, pass or so, that anything that's kind of based on somewhat, of a novel economic theory these days, courts are very skeptical. Partly, rightfully so. In the sense that, if you just have a theory that, yes, it's a possibility theory, could be holding, and here's some facts that are not inconsistent with it, that's probably not enough. You need to have more than that. And in many of these cases, it's just either the data doesn't exist or it's too hard to get a very conclusive argument. And there you could sort of imagine having an environment that's, I hesitate to call, Europe, regulatory environment, but more of a regulatory environment compared to our legal system. You could see that would make it easier to get cases through, even though you could say, look, this fits exactly this precedent, or, under this this law. And I think as a result, you see a lot of calls in the US to say, what we really need is, it's not about changing the law. This is actually about let's form regulatory bodies that now could actually make the regulatory determination. And, and to be honest with you, I was very much against it until we got the Sabre decision. And at that point, I'm like, oh, maybe it's not that bad, being on the other side of the decision. But, more seriously, kind of stepping back, we have to be very careful with it. Yes, there might be, concerns about the direction the Supreme Court has gone or the courts are going. But if you're going to set up a regulatory environment, you have to remember, even if you say, look, I like it because I get to be the decision maker for the next X years, 4 or 8 years or whatever, at some point that's going to end, right? Whether it's going to be a different administration or a different person within that same administration making decisions. And how are you going to feel about that if the person making decisions that can make, pretty much just determine this is good, this is bad, is not exactly aligned with your preferences, whatever those preferences are, right? Whether you're conservative or liberal, you have to think of, do you want to set up that system? And I think that's very dangerous. And, you know, maybe it would be a last resort. I don't think we're quite there yet. And for those advocating for a more European system, I just want to sort of point out, just stepping back, looking from the grand kind of economic perspective, you know, a lot of the innovation, a lot of the success that I see is actually coming out of the US. I mean, not to say that, you know, Europe doesn't have any innovation or any success. That's wrong. They obviously do. There's a lot of innovation, a lot of really good stuff happening in Europe. But, you know, it's not like you just look at a high level and you say, wow, one system clearly dominates the other in terms of outcomes. So we might have to think a little bit more carefully before we try to edge too close to what we perceive as European system.
If I could add just a word about regulation. We have a long history of regulation in the US. It goes way before the New Deal even. The Interstate Commerce Commission was created in 1887. Historically, we have applied regulatory regimes to sets of firms that engaged in a common enterprise with a common set of technologies. Airline regulation, communications regulation, electric power, natural gas, and so on. One of the things you got to confront if you talk about regulating the platforms is they are incredibly diverse from one another. They do offer some overlapping services. They offer a lot of different services, but to come up with a regime that simultaneously regulates, for example, Google, Facebook, and Amazon, that's going to look entirely different from something like the Civil Aeronautics Board of the 1960s or the Federal Power Commission that basically take a group of firms. They're somewhat differentiated, but they use a common technology and they do pretty much the same thing. And so you can come up with a common set of rules that govern them. It's not going to be so easy with the platforms.
Well, to pick up on something both of you said, there's no question that they actually, in the new competition tool, they're talking about as an anti-regulatory system. UK, the Furman report called for regulation. The ACCC's report from Australia called for regulation. I mean, that's very, very much in the air. You know, it's interesting, we forget, a lot of people, I actually started as a regulated industry scholar, and there's a huge literature that says all that stuff didn't work that well. You know, it was not innovative, it facilitated collusion. I mean, you name it, there's a whole host of criticisms, not the least of which is, if we're really talking about non-discrimination, what the economists would tell you, non-discrimination is a price differential that's not justified by differences in cost or product quality. And so if you have different technologies, you know, production technologies and costs where are they vary widely, our ability to police non-discrimination becomes incredibly complex. Probably beyond the tools, certainly what antitrust courts can do, but even many regulatory agencies, they've really struggled to do that. It's fascinating to me. And so there's a lot of stuff when people turn to regulation, there's a history there, which a part of the initiative that we're leading here at about digital, looking at the digital economy, we're going to start to explore in the months to come to try to make sure that we learn those lessons. Now, I want to throw out, before I get to just one question, I can't resist, but when you were both talking about the App Store, I really have always thought about this through the lens of Tim Bresnahan, Mark Trachtenberg's article on general purpose technologies. They said, people who make platforms create value to complementers that they don't internalize. And so there's a sort of a systematic underinvestment in the platform. And their solution was to allow the platform, the GPT, to vertically integrate into some of the complementary technologies so they can internalize them. And so the idea that a platform like Apple would be generating some revenue from, or claiming some of that revenue, maybe we can quibble about what the number is, but seems to be consistent with consumer welfare in some ways. And I have some work on modularity theory that says much the same thing. It distributes it to the outside. And so I'm fascinated, how do we sort this out in terms of these policies that Epic and Spotify are objecting to when there actually seems to be some plausible justification for it?
I think it's like all instances of vertical integration. Most of it is pro-competitive. I would think most instances of platform vertical integration would be pro-competitive, but in the presence of significant market power, not necessarily. And I think those are the arguments that both Apple and Android will be confronting. These are doing that in a competitive market is really not a problem. The question is whether Apple's hold on iPhone owners, there's a certain lock-in element here as well. That is to say, is that market power, the hold that iPhones have over, that Apple has over its own iPhone owners. If that is significant market power, then this may just be carrying vertical exclusion a little bit too far.
And Christopher, you have to remember that we're not talking about an app store that's up there alone. That's the only thing that they do, right? I mean, the app store is owned by Apple, right? Apple sells devices that it has an incentive to make sure those devices, you can do stuff with them, right? And if you can do stuff with their devices, which you can do by downloading apps, you will pay more for the phone. So they already have a way in which they can actually get attribution for the value that they're bringing. Right now, I think it would be very different if the App Store was a standalone entity. You said, look, it's actually creating a platform by which creating basically a marketplace, right? It's creating a marketplace by which consumers can actually meet developers and download, and you have to compensate that platform. But here, the platform, especially in the Apple case, is or potentially is compensated by the devices. And looking at Apple's profits, it'd be hard to claim that they're not properly compensated.
Yeah, I mean, the other thing, Christopher, is that argument should apply equally to laptops, desktops on one side and handhelds on the other, but the stories are very different. Yeah. Windows 10 is a very much more open platform when it comes to making online purchases. You can, if you want to buy software and you're on your Windows machine, you can go to Egghead, you can go to Amazon, you can go to many different sources, and Microsoft doesn't take a big commission just because you bought it on somebody else's source. You get on your iPhone, it's an utterly different experience.
Well, I think that's a fantastic place to at least turn to. I'll probably get as many questions in as I can, but moving from our discussion, just picking them with apologies because I know I won't get to all of them. John Mann asked a question. What about relaxing the potential competition standard for deals proposed by dominant firms, either by a presumption that such a deal is illegal or dispensing with the need to show a small firm would succeed? Much more generally, we haven't talked much about potential competition doctrine, which is controversial in its own way. It has never been fully, there's aspects of it fairly fully accepted. Let me ask you more generally. Can we turn to potential competition doctrine as it is or as a modified version to address some of this without is that a tool that can get us to answer the questions we have here?
Well, I'll give you my answer. It's going to be less sophisticated than Aviv's, but number one, the language of the Clayton Act is very broad. It covers any acquisition whose effect may be substantially to lessen competition. It doesn't prescribe anything about the market relationship between the parties. And it uses this very prophylactic language, whose effect may be substantially to lessen competition. I don't think we need to have a statutory amendment to do it. What we do need to have is some more serious modeling and thought given to how platform acquisitions function. And here I think we need to start thinking more about dealing with them as exclusionary practices, which is not robust in the tradition of merger analysis. We usually think of mergers in terms of collusion, either market-wide collusion in traditional merger cases or price hikes between the merging partners in unilateral cases. But I think the better way to think about platforms acquisitions is as acquisitions that are designed to enable the platforms to maintain dominance by getting rid of potential competitors down the road. And that's a different form of analysis. It's one that the Clayton Act permits, but we would have to convince judges that it's an appropriate concern in merger policy.
So, look, I think it touches on the same issues that we had before. I mean, you could say, look, in terms of, taking the more complicated theory and turn it into simpler thresholds, you might say, well, we do want to have a threshold that depends on the size of the acquiring firm. I will point out, by the way, that the current threshold for HHIs obviously would not be sufficient in most nascent competition, but in them built in by the current thresholds that we have to look in, if the acquiring firm is larger, right, you will get a larger delta HHI, right? Just from the math of it, right? The delta HHI is 2 times the product of the shares. And if you have one firm that has, a 50% market share, you multiply that by 2, and then you don't need a very large market share for the other firm, right? So it has in it, if you want, built in this type of idea that what is the threshold for being worried about stuff? It varies with the size of the acquiring firm. Okay, now you could sort of say, that's fine, but the current threshold of, let's say a delta of 200, a delta HI of 200, that's way too strict and definitely is not going to do anything if the acquired firm has a 0 market share. It doesn't matter how big the other firm is. So I don't know, I think probably when we start thinking about things, if you actually have a dominant firm that's acquiring a potential or nascent competitor, you'd be more worried about it when it's dominant versus when it's, large but not as dominant. But I think it's not just a matter of, okay, let's have different rules. It's also a matter of how do you fit it in and convince judges that it's a real concern. And, if you look at something like, again, Sabre, a lot of it boiled down to this 2-sided platform cannot acquire or does not compete with a 1-sided, but there was a lot more to that. Even if you put that aside, I don't think the judge was actually convinced by some of the arguments of potential competition. And I think those are the type of issues that one would have to deal with.
Well, with apologies to the other people who have asked questions in the queue, all of which are very well taken, we are 1 minute from the end. So rather than indulging a question which would take probably too long, I will open it. I will give it back to Herb and Aviv for any last words you might have.
I'm actually good. I think we covered a lot of ground. I want to thank Christopher for being such a masterful host.
Yep, same here. Thank you. And 1 word or 2 words is stay tuned. I think a lot of interesting things to come in the next few months.
Wear your mask.
Yeah. Well, there's that, but more importantly, I think what Aviv's getting at is, we were chatting before the chat began, is antitrust has not, during our lifetimes, always consistently been a hot topic. It's hot now and likely to stay that way for the foreseeable future. So I'm sure this will not be the last program we do on this. We will continue to do some into the spring, a variety of topics. We encourage you to sign up for CTIC's mailing list if you've enjoyed this, to keep your eye out for future programs. And I thank you for joining us today. And we look forward to seeing you at a future CTIC event. Thank you very much.
Thank you.